Good afternoon, everyone. Welcome to our webinar. It's back, 2021 COVID Back to School Update for Texas Schools. I'm Jackie Godapur-Werns, and I'm a partner in the Dallas office of Thompson and Horton. I'm joined today by Houston partner Chris Gilbert and Austin partner Holly McIntosh. Welcome, Chris and Holly.
Glad to be here.
I'm going to double check and make sure we're giving people time to roll in before we get started. Give it a few more seconds. All right, it looks like we've slowed down a bit, so let's jump right in. So to say that this year's back to school has been a whirlwind is a major understatement. Schools are in the middle of battles between the federal government and the states, between the states and their school districts, and between school districts and their parents. Today, we are going to take a deep breath and a step back and discuss where we are and where we're going with COVID-19 in school. We will also try to answer your questions if time permits, so please submit them using the Q&A function on Zoom. If for any reason we're not able to get to your questions, please feel free to reach out to any one of us or to any other Thompson and Horton attorney for more assistance. Before we jump in, please mark your calendars for our next webinar. In 2 weeks, we're going to bring you a webinar on what's new with social studies, critical race theory, and classroom instruction. If you're not already signed up to receive our alerts by email, please make sure that you do so. And of course, make sure to follow us on Twitter, Facebook, LinkedIn for all of those announcements. All right, with that, let's dig into our topic for today, our COVID back to school update. So Holly, perhaps the biggest issue in Texas school law these days, and one that you and I know have been thinking about a lot, is masks. Thompson and Horton has been honored to represent a number of large school districts that intervened in a lawsuit seeking to show that Governor Abbott's prohibition against schools requiring masks was beyond his authority. We've represented and counseled schools across the state, whether seeking to enforce a mask mandate or seeking to comply with the governor's order. And so we can start out by giving our audience an update on where things currently stand in the realm of mask litigation.
Well, where they stand now and where they stand 30 minutes from now may be completely different, but I can at least start off by telling you, kind of giving you a little bit of background. As most of you know, on March 2nd of last year, or this year, but last school year, Abbott lifted COVID-19 restrictions in Texas. However, school districts were the exception, and they were allowed to continue following TEA guidance, meaning they were not required to stop mandating masks like other local entities were, because TEA said you should still do masks, or at least that's the default. You got to pick, but the default was you should still require masks, and if you wanted to change, your school boards could, by official action, a vote of the board, decide to lift mask requirements. Then on May 18th, near the end of the school year, the governor issued another executive order, and this one banned mask mandates by public schools starting June 2nd is, I believe, the date. June 2nd? No, June 5th. Sorry, June 5th was the date that you would no longer require masks. And as most of you know, that was, first of all, before the Delta variant and also in the middle of the summer. So most school districts were not overly concerned about not having a mask mandate when most employees and most students were not on campus. It's a lot easier to social distance during summer school than it is during the regular school year. And then on July 29th, in the middle, as the Delta surge was really beginning to make a push, the governor issued another order confirming once again you're not allowed to issue mask mandates, according to him. And it provides for a $1,000 fine for local officials who adopt a policy that is inconsistent with the executive order. However, as you also probably know, many school districts across the state adopted mask requirements anyway in efforts to keep their students and staff safe. They believe that the executive order was not lawful, that it exceeds the governor's authority under the Texas Disaster Act. And because litigation ensued is one way to put it. There has been a ton of litigation between counties and the state, between the state and school districts. Sometimes, for most of these, the counties or school districts who wanted to issue mask mandates were suing the state, asking the courts to say that the governor's order was invalid. But then just last Friday, the Attorney General started suing school districts, and he sued 6 school districts on Friday. He sued another 9 on Tuesday. And as far as I know, he hasn't sued any today, but we'll see what happens by the end of the week. He may be on an every other business day schedule. And so that's where we are now. We're waiting for all of these to work their way through the court system. So far, every school district has been allowed, who has sued, has been allowed by the trial court to issue a mask mandate, except for one court in Fort Worth ISD. That particular court said that when parents sued the school district, that district court said you can't have a mask mandate. However, that's now on appeal, and the appellate court lifted that order preventing them from having a mask mandate. All of the other school district cases are also on appeal, and those the school district won, but every governmental entity gets to take advantage of the same stay that Fort Worth did. And so while in Fort Worth they lost at the trial court level, but that ruling is stayed or on hold. In all the other cases where the school districts won, the state got to take advantage of that. And the ruling saying that districts got to issue mask mandates is stayed. So right now, basically, we're exactly where we were at the beginning of August when school districts started issuing masks. There's no court order saying you can't. There's an executive order that the Attorney General and the governor thinks means you can't. And there are a lot of school districts who think that that order is unlawful and that they get to if they want to. The position Thompson Horton has taken in all of these lawsuits is that it's up to you. That's but frankly it, that you as a school district get to decide what measures you need to put in place to protect the health and safety of your students. We don't think that you can be required to issue masks, and we don't think that you can be banned from issuing mask mandates. So we're just pushing for local control for all of our time.
Well, that is a lot of uncertainty that you described, other than I guess we can all be comfortable with the certainty of what position we're taking in these cases. Hopefully we'll get some certainty from the courts on the position they're taking soon. But in the meantime, what should schools be thinking about when they're considering their options to require or not require masks in schools?
It really is it's going to be the lawyer's favorite answer of it depends. It really matters what your local area is saying. There are a couple of reasons why this matters. First of all, the only express means of enforcement, which is the one that the Attorney General pointed to for the first several weeks of litigation, is the DA's in your area. So the district attorney gets to decide whether to go after the officials who implement mask mandates for this $1,000 fine. In a lot of counties, you're not going to have a problem with that. You can just you can issue your mask with confidence that the DA is not going to come after your school board members or your superintendent. But in some counties, the DA might be willing to prosecute. And likewise, what we've seen so far is that the Attorney General is much more likely to sue you if you live in a smaller county, which is also more likely to have, not smaller, but they are often smaller, but the more rural conservative areas of the state, in addition to having more conservative district attorneys, also have more conservative judges, and the Attorney General is taking advantage of that and suing districts in more conservative areas in the state. And not just rural, some suburban as well, but depends on the politics of your local area.
All right, well, I don't see any questions. If anybody has questions about the mask litigation, don't hesitate to drop those in the Q&A, but we will go ahead and move on to talk about litigation at the federal level. So Chris, can you give us an update on the federal litigation that's currently pending that might impact the use of masks in Texas schools?
Sure. There are a number of lawsuits around the country that have been filed regarding masks, both pro and con. With regard to state court lawsuits in other states probably don't provide a lot of guidance to us in Texas because they tend to be very focused on state law. And state law obviously varies a lot. So that doesn't necessarily mean a whole lot to us. But federal court lawsuits, generally speaking, are going to be looking at things like the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and then possibly constitutional provisions. So those cases, even though they're in different parts of the country, may still have some meaning to us here in Texas. Now, in Texas, we have a federal court lawsuit. It's ET versus Abbott. It is filed in Austin in the Western District of Texas. It was filed by a group of parents arguing, these are parents of special education students, and they're arguing that because their students are more susceptible to COVID-19, that the governor's mask ban deprives them of an equal access to education and thereby violates the ADA and Section 504. And essentially what they're arguing is that schools can't reasonably accommodate the students by requiring masks because of the mask ban. So they have filed that lawsuit. Now, interestingly enough, they had a hearing yesterday in Austin. The plaintiffs were asking for a temporary restraining order, which is an order that for 14 days bans something in a lawsuit. The judge in the case denied the TRO yesterday, but the judge set the case for trial on October 6th. So there's going to be a very quick trial in that case. And we will have some guidance from the court there as to whether federal law prohibits the mask ban. The judge said apparently that he just felt like he didn't have enough information at this point to grant the TRO, but he set the case on a fast track. So we'll get some guidance in early October. Did I say February? October 6th, as to how the federal law impacts this. There are a number of other federal lawsuits around the country. There's one in Des Moines, Iowa. It's the same lawsuit. A lot of these lawsuits are brought by Disability Rights Texas, and they tend to be very similar lawsuits. The one in Iowa is very similar to the one here in Texas, except the judge there granted the injunction. Iowa has a state law that bans masks, and the judge there enjoined that anti-mask law while the lawsuit goes forward. So school districts there, according to some of the press releases, are starting to require masks again. South Carolina has a very similar lawsuit. The one in South Carolina is actually over a budget rule. The state passed a budget rule preventing schools from using money from the state if they were requiring masks. And so parents have filed a very similar lawsuit there. Now, there are also federal lawsuits filed sort of from the other direction. So in Winslow, Maine, there is a federal lawsuit brought by a father who says that in Maine, they require masks. And so there, the father is arguing that the mask requirement violates his 14th Amendment right to direct the educational and medical upbringing of his children. This is an old theory. It pops up every now and then. For those of you who follow these things, this was the theory in the Wisconsin versus Yoder case, which was the case that allowed the Amish to opt out of school after the 8th grade. Since that case, very few courts have relied on this theory to grant relief because, frankly, it leads to educational chaos. If everybody can kind of go in and say, this is what I want, this is how I want to raise my child, schools aren't really cafeterias in the sense that people don't go through and pick and choose. So that theory hasn't been very, very successful, but we'll see how it works out in Maine. And then there's also a lawsuit in Palm Beach County in Florida, another federal lawsuit where families are arguing that the mask mandate there violates the constitutional rights of their children. So we'll see how some of these other lawsuits turn out, but we now have differing judgments from the Texas case and the Iowa case.
And very interesting. And just to clarify, they're all applying the same the law, the same law,
Yeah.
since it's a federal court. So it'll be interesting to see how this continues to shake out with different courts across the country addressing the same question and reaching different results. Eventually, hopefully, it will make its way to the US Supreme Court, but that would take some time.
Well, and remember, the Supreme Court tends to take cases where you have a split between the various circuits or the various states. So if you've got Texas saying one thing and Iowa saying another, that's the kind of issue that tends to get to the Supreme Court.
Maybe we'll get an answer before we know it. So the U.S. Department of Education's Office for Civil Rights, my former employer, they have also waded into this territory as well. So what is happening with OCR and masks?
So they have. OCR is launching a number of investigations around the country. To date, it looks like they're investigating 6 states. They just opened an investigation in Florida. And the theory that OCR is looking at is largely the same theory that the plaintiffs are asserting in some of these cases, the ones that are attacking mask bans. So OCR is looking, according to their official press release, the investigation is whether statewide prohibitions on universal indoor masking discriminates against students with disabilities who are at heightened risk for severe illness from COVID-19 by preventing them from safely accessing in-person education. So that's the issue that they're looking at. Currently, in addition to Florida, they're looking at that. They've launched investigations in Iowa, Oklahoma, South Carolina, Tennessee, and Utah. They actually specifically said that they were not looking at Texas along with Arkansas and Arizona because at the time they started their investigation, there were enough court rulings in Texas that essentially had enjoined GA 38, which is the governor's order on masks. Now that we don't really have as many of those orders, or now that it's a little bit maybe less clear, OCR may look at Texas. Likewise, they started an investigation of Iowa before the court order in Iowa stopped the application of that law. So their investigation in Iowa may be held off. But that's the issue that they're going to look at. And again, they're focusing more on what the state is doing, not necessarily on what individual school districts are doing.
Yeah, and from the perspective of having worked at OCR, and just to explain a little bit about how the procedure they're using for these cases, they're doing this through directed investigations, which means they don't have a complaint from an individual. They've just decided based on news that they're seeing and other information that's available to the public that they think there might be a violation of the ADA or Section 504 that's happening in these states. You could very well see complaints from individual parents trickling in over time if there are parents or guardians of disabled students who want to make similar arguments that are being made to the courts. They could make those same arguments to OCR. It's interesting that we haven't really seen that much of that yet, but it is certainly something to keep an eye on that might be coming up in the future.
And my only guess on that is my suspicion is that OCR will continue to focus on the state because obviously with all due respect to your previous employer, we all know that their investigations are not always the fastest things in the world. And so launching an investigation into a lot of different individual complaints by parents would probably use up a lot of their resources. My guess is they can move faster if they focus on what states are doing. And that's just my suspicion at the moment.
Yeah, I think you're right. I was talking to a reporter about this when the news first came out, and I said I thought that this was OCR's effort to just try to be involved in the conversation, to try to put some pressure on the state governments to make a different decision, with the recognition that even a directed investigation is usually going to take 6 months to complete. And so by that time, maybe COVID will be over. Probably not, but I can dream, right? So yeah, I think you're right that that's probably what they're trying to do, is some mixture of just put the pressure on and maybe get things done in a more quick way to actually effectuate some change.
Right.
So before we go off the topic of masks, Holly, I was hoping to ask if you had seen any creative arguments by school districts that are thinking about requiring masks in their buildings, and how much success do you think those arguments could possibly have?
Well, one of the creative ways that popped up early on was the idea of you putting a mask requirement in your dress code. So just the same as you would put uniform requirement or something similar to that in there. It would be a requirement that students wear masks in the dress code. The Governor Abbott and the Attorney General have both insisted that there is no legal loophole to work around the executive order. Now, I have to say, I tend to agree with them that I don't think this is a legal loophole. That I believe that you do have authority to require masks, but the authority to regulate dress comes from the same place as the authority to control other discipline issues, health issues, safety issues. They all come from the same place, and that's your school board's general authority to be in charge of how your school districts are run, and your superintendent's general authority to be the chief executive officer and manage the day-to-day affairs of the district. And so either the governor has authority to supersede that authority through his executive order, either the Texas Disaster Act allows him to do that, or it does not. And if it does, it's going to override the laws that allow you to have dress codes, the same as it's going to override the others. I will say that the Attorney General, we were wondering, and one of the lawsuits that he has filed in the last few days was against Paris ISD, which, along with Texas City ISD, are two of the school districts that I know have put this into their dress codes. And as part of that lawsuit, so that's proof that the Attorney General agrees with the governor and that he doesn't think that this is a loophole. And in addition, a court issued a temporary restraining order against Paris ISD enforcing their mask requirement from their dress code. Now, that said, this was one of the TROs that this is one of the orders that the Attorney General got by going into court without the school district being present. So neither they nor their lawyers were there to highlight this issue for the court, or to even point out that it was as part of the dress code. The Attorney General is certainly not going into that level of detail in his request for temporary restraining order.
And I agree with Holly on that. I don't think it's a clever legal loophole to get you around G838. The one reason why I think school districts might want to consider putting it in the dress code is because it helps out a little bit in determining how to discipline a student who doesn't wear a mask. So I've got a number of calls from school districts that say, look, we have a mask mandate, we require masks. What do we do with a kid who comes to school and won't wear the mask? And if you have it as part of your dress code, one of the advantages there is that your dress code already has built into it sort of what the discipline is for not following the dress code. So if it's part of your dress code, then you can discipline a student the same way that you would discipline them if they didn't wear shoes or if they refused to wear a shirt or something like that. So I think it helps a little bit on the administrative side, but I don't think it's a magic panacea for the legal issues.
Yeah, that makes a lot of sense. Another area that another creative option I've seen some people do is that they're doing a mask requirement with an opt-out. And now I will say this, that if you have a mask requirement, you need to have an opt-out for reasons of disability or religion or any of the other reasons that students can opt out of certain requirements to avoid federal discrimination law problems. But what this is you don't even have to have a reason. So what some districts are doing is saying, you're required to wear a mask unless the parent goes online and requests that they not be required to wear a mask. Part of this is just taking advantage of the general idea that marketers all around the world know, which is that if you have to opt out, you're more apt to get it, as opposed you're going to get more people getting that thing than if you have to opt in. So the part of that is just to get there around the margins. And I also think that there's something to be said for the fact that if you have that and the parent hasn't filled out that form, that gives teachers authority to enforce it in a way that they don't if it's just because a parent sends their kid to school in a mask and the kid takes it off and puts it in their back pocket. So I think that's one advantage that it has. I know that talking to friends around the start of the school year, there was some concern that there might be bullying on either side because of students wearing a mask when other kids bullying them because they were, or the other way around. But I know plenty of people who were concerned about sending their kids to school with a mask and concerned that because of peer pressure, they were going to take it off. And this one, I don't know if it eliminates this, but it takes a little bit of that out when the teacher is enforcing it.
And there is some legal authority that by analogy supports that. The Texas Pledge Law, the Pledge of Allegiance law, specifically says that students are required to stand for the pledge, but if a student doesn't want to, they can sit with written permission from their parents. And those kinds of parental requirements have actually been upheld by the courts. There's a case out of Florida, the 11th Circuit, that upheld their pledge law that had a very, very similar provision and said that that was a legitimate exercise of a school district's attempt to work with parental rights and acknowledge parental rights. So I think that that kind of provision has some legal support for it.
And what I think is interesting about this particular creative out is that while the Attorney General and the governor have said very clearly that putting the mask in the dress code is a violation of the executive order and it's not, there is no legal loophole. The difference here is that the governor does say you can encourage mask wearing. In fact, the governor encourages mask wearing in the statement. And so it's an interesting thing to think about whether or not, we don't know yet. I have not seen a suit by the Attorney General against somebody who has this opt-out provision. I should be knocking on wood on behalf of all those school districts, as I say that. But I do actually think that there's a strong argument here that this particular creative out is actually entirely consistent with the executive order, whereas in all the other lawsuits, for the other school districts, if you get sued, the position has got to be, well, the governor's order is invalid and he can't require me not to have a mask mandate. In this one, one of the arguments can be, no, this isn't prohibited by the executive order.
That's very interesting. And Holly, you mentioned bullying. And when we were preparing for this webinar, we talked about how we read lots and lots of articles that talked about the concerns about bullying. And we haven't really seen very many instances where schools have been contacting us about instances of bullying. So let us know in the chat or the Q&A if you have had any bullying situations. Let us know, and we'd love to hear about your experiences in that realm.
And just jumping in, speaking of the Q&A, we have a question here asking what districts are doing with the districts who have an opt-out are doing with their staff. So if you have an opt-out provision, can your staff opt out? Do you have to allow them to opt out, or can it just be for students? And if the reason you have an opt-out is because you want to be able to say, I'm not violating the executive order, you'd have to give it to staff as well. If what you're doing is really just trying to avoid parent battles, then you wouldn't have to. It just depends on your motivation for taking that particular method.
So, Chris, I've heard that some schools are arguing that even if masks don't prevent COVID, which is an area of contention, that they mitigate absences right now, because anytime someone has a close contact with a positive person, if a student has close contact with another student who's positive, or staff members, those individuals all have to quarantine. And so what do you think about the argument that that masks are warranted for that reason?
I don't know that that makes that much of a difference from a legal standpoint. I don't know that that argument changes the legal calculus that we're doing it because we're avoiding absences as opposed to trying to prevent COVID. I do think, though, that from a messaging standpoint, that message may resonate with some people, because I think there are a lot of people out there who are just, for whatever reason, convinced that masks don't prevent COVID, and that arguing, well, yeah, but this is the world we live in. There are rules we have to follow. And if you have to quarantine, we're going to have absences, and we're trying to avoid absences. You know, that kind of argument might at least sound a little bit better to some people.
So we did get a comment that I'll read out from the chat, from an individual who says, we've not had complaints of student-on-student bullying about masks. However, parents who don't want their students wearing masks have alleged that administrators and teachers are bullying the students by requiring them to wear masks. And yeah, that is something that that I've seen. It actually came up in the legal papers for the Fort Worth lawsuit as one of the justifications against having a mask mandate. So definitely that is something that maybe we weren't expecting to be seeing, and we're seeing a fair bit of.
Well, and it always raises that age-old issue, how much of this is really an issue with the parents and how much is an issue with the kids. Back when we were dealing with transgender issues, my experience at least was that a lot of the kids were perfectly fine with everything that was going on. It wasn't a big deal to them. They knew transgender kids, they were friends with them. It was the parents who didn't have that kind of contact that were raising a lot of the issues. And so a lot of this mask, every time I sit in a school board meeting and I hear people, complaining about masks, I just kind of wonder, do their kids really care or not? There was a guy who was actually talking about masks and admitted that he didn't want masks, but that his kid wanted to make, he had I think a kindergartner, wanted to wear masks because it made him look like a ninja. And so he wanted to wear the ninja mask, and the parents I just gave up and told him, okay, fine, you can look like a ninja and wear your mask. So sometimes I think the kids are a little ahead of us adults on some of these issues.
Yeah, and it may just be a matter of resilience and it being more difficult for us. I know for me, I can think of so many instances where I've meant to have a mask with me and I get out of the car and I get to wherever I'm going and I've forgotten it because we're so much older and more trained at it. But my kids, on the other hand, will be in the back seat for 20 minutes and I'll turn back and say, you can take it off now. So maybe it's just a matter of teaching, easier to teach young dogs new tricks, I guess.
Exactly.
So what other enforcement issues are we seeing right now, Chris, with respect to wearing masks?
So, one of the issues I think that we're going to see, we've already seen a little bit of it, and I think it's going to become a bigger issue, is this kind of question of civil disobedience from both sides. If you have a governor order, and we have one, and it says you can't require masks, and school districts require masks, in a sense, they're engaging in civil disobedience. And so to the extent you do that, are you then encouraging your people to engage in counter civil disobedience? So governor says no masks, school district says masks, I'm not going to wear a mask, and law is a fragile thing. We know from speed limits that they only work as long as a significant number of people are willing to follow them. So to the extent we don't follow the rules, whether we think they're good or bad, to the extent we simply decide not to follow them, I think it encourages, it's a bad example. And I think that's one of the arguments you hear is it's a bad example for parents, it's a bad example for students that we're not following the rules. I think another issue that we need to think about is, as with a lot of things, I think the mask controversy has been cast as sort of a false dichotomy. Either masks, some people it's 100%, man, masks will save the world. And then other people are 100%, they don't work, they're never going to work. And I think in reality, as with most things, the truth is somewhere in between. The point of masks is not to completely prevent or eliminate COVID, it's to reduce the risk. And so, yes, masks aren't 100% effective, but they certainly help. And I think that we need to remember that when we're talking to parents in the community, but from both sides. So, when we have somebody who doesn't want to wear a mask, maybe because of health reasons, maybe because of personal preference, maybe like Holly said, the school district has an opt-out provision. I think school districts do need to make some effort to explain to people, again, from sort of a balancing of the risk, the fact that one person is not wearing a mask or a couple people is not going to necessarily create a COVID pandemic in the school. It increases the risk a little bit, sure. But, we've had to deal with that over the years with other things where we have opt-outs for dress codes, long hair requirements. Who knows what's going on with those right now. But, we've always had an opt-out for people who had religious objections or things like that. And it is difficult sometimes to go to people and say, wait a minute, my kid wants to wear their hair long. How come that child gets to wear their hair long? And you have to explain, well, it's because they have a religious belief. And sometimes that is difficult. And I think sometimes here we may need to do that. We may need to reach an equilibrium going forward where we strongly encourage masks, but we acknowledge that there will be some people who may not be wearing them. And maybe that's okay. And maybe we just have to try to have a dialogue about that with everybody.
So we did get a question, would requiring face shields violate the order? The order, my understanding is the order says face coverings. So face shields would be covered. just like
I
other
have it right here. I'll
masks.
look it up. I thought I had it.
I pulled it up because I saw that while you guys were talking.
Yeah.
And yes, it does say face covering. So I
Face
wanna confirm.
coverings.
Yeah.
Yeah.
And it does not define that term, but I would not want to be the one in court arguing to a judge that did not include face shield.
Yeah, I think that the argument, the local control argument might be easier than the face shields argument. Not to say it's easy by any means, but the face shields argument might be a tough one to win. All right, so let's talk a little bit about for those school districts that are requiring masks and they are going to be fielding requests from employees, for example, that they not be required to wear a face covering because of a disability. How should schools handle those types of requests?
I think, again, I think it's going to have to be a little bit on a case by case basis. And I think that we need to use the ADA's interactive process as sort of guidance for how to have these conversations. Because I think in a lot of cases, there may be other options, maybe not a mask, but maybe something like a shield or a plexiglass wall or something like that. There may be other things that a school can do to address the concerns that the employee has that are short of telling every student in the class that they have to wear a mask, if that's what the employee is asking for. I do think that that's going to be one of the bigger problems going forward, are going to be employees who are either having health issues or are concerned about having health issues and that are asking us, to require masks. I think that's going to be a bigger issue going forward than with students.
Well, let's talk about that, because that's another question I have for y'all is what do you do on the opposite direction? If you have an employee who comes in and says, I do need other people to wear masks around me. Holly, what do you think about that?
Well, I think that, again, I'm going to say it depends in terms of whether or not, and the ultimate result will depend on the situation. The starting point is the same. You go through the ADA interactive process. You need to see why it is what disability they have that requires them to wear a mask. Is there some other accommodation that you can put in place instead of requiring students to wear a mask? Can you put a shield around the teacher's desk? And can you implement social distancing? Could you even have class outside most days? Could this, if you, let's say you use it, one thing to do is just to use it as a sort of nudge to have kids wear the mask. If you tell parents that this teacher has this issue, some who would otherwise say, no, my kid's not going to wear a mask, might say, you know what, in your classroom, I'll have them wear a mask. And if not, there might be ways to move the student around. You can transfer that student to a different class. You might come into some issues if the student, you're obviously going to come and run into issues if it's a special ed student, because there may only be one classroom that has that particular setting and provides those particular services. But in most instances, you will have another class that you could send. If there's a small number of students who won't wear a mask, you could send them to that other teacher. And while a student might have an argument that a student would have an argument that under the executive order, let's say it's a gifted and talented teacher and they're doing pullouts with students, and if you stop letting them do the pullout, the governor, I think, would very quickly say that violates his order, because you're conditioning that child's GT services on wearing a mask. But if you have more than one GT teacher and you can have them pulled out by somebody else, they're still getting that service, and there's no guarantee for any student that they be served by a particular teacher. And that's true even of special education students, but you do have to make sure it's the right setting. So it's going to be a lot harder if it's a special education teacher. So but really you just got to think creatively. Is there a way to meet this teacher requirement that doesn't involve masks? And then if there isn't, then you have to look at the circumstances of your school district and determine whether you can feasibly grant it, or whether you can argue that it's too burdensome.
Going back to the federal litigation cases that we were talking about, if an employee challenges a school district's refusal to require masks in the classroom, presumably they would do that under the Americans with Disabilities Act or a similar law, and that's a federal law. And so generally speaking, federal law trumps state law. And so I assume in those cases that they're going to make the argument that the ADA trumps the various state law bans, because those state law bans are preventing the school district from reasonably accommodating them. But it's interesting. I haven't seen an employment case yet. I'm sure there's probably one in the works. Although remember, before you can bring an ADA claim, you're supposed to go and file with the EEOC. So presumably we wouldn't see one of those lawsuits for a while unless somebody tries to make the argument that the EEOC process would be futile and that somehow they're excused. So that's probably why we haven't seen one yet. My guess is there are some in the pipeline, but I assume that same argument would be made by employees against the mask bans.
Such a good point. And the same issue arises with students, right? So if you have a student who's making the request instead of an employee, in most cases, you're dealing with federal law. If that student particularly has a disability, you might be dealing with IDEA, you might be dealing with Section 504 of the Rehabilitation Act. What does that analysis look like for schools if they were to get a request from a student, either that I can't wear a mask or I need other people around me to wear a mask?
First I would say consult your special education expert, and that's not me. But I would say that I do know that you're going to have to, if it's a special ed student, you're going to have to go through the IEP process. If it's a 504 student, you're going to need to consult the 504 plan. First of all, look and see what disabilities are they already diagnosed with, right? That's one thing you have a step up on compared to employees. You're going to have that information at the ready. You may need to do a new evaluation if they're saying no, there's this other issue. But also remember that you have a built-in process for them, just like you do for employees, but it's just a more specific, very step-by-step process. The thing that I've been thinking about this whole time as we've been talking is, what do you do if you have two students in the same special education class and one is saying, I can't wear a mask, and the other is saying, I'm immunocompromised and everybody around me has to wear a mask. It's just going to be difficult. And I'll also be curious to see, and I'm saying this only to our friendly audience because I wouldn't want to give parents attorneys any ideas here, but I would be curious to see what happens going forward with immunocompromised kiddos. Are they going to be even post-pandemic saying, but wait, what about flu season, or what about other issues that can cause concerns? Are parents going to be seeking to have students in their class, or other students and the teacher in that student classroom required to wear a mask to protect their kids?
Well, Holly, you could have fooled me that you weren't an expert on that. You think you did a very good job fielding that question. I think it's very funny how those of us who do some disability work, we're always like, but make sure you call one of our special education experts at our firm as well, because they really know their stuff on that. So for students, though, from my experience at OCR, I will bring up thinking about back to Chris's comment about the Pledge of Allegiance case providing some precedent here. There are decisions from OCR in which OCR has said that other students in a classroom can be required to give up some right in order to protect a disabled student who has a 504 and is in that classroom. So in the specific instance, it was recording. So a school said that they did not want to allow recording of a classroom for a disabled student because it would infringe on the rights of the other students who were there, their rights to student privacy under records laws. And the OCR said you can't make contingent on other people's consent protecting that student in that case. Now, obviously, requiring students to undergo recording and requiring students to slap a mask on their face are two very, very different things. But it is at least interesting that there is some precedent in OCR's history where they have said, if you have a student with a disability and if they really do need something in order to access their education, we might not be concerned about the quote unquote rights of the other people in the classroom as much as we are with the rights of the student with a disability.
Well, it's kind of like a peanut allergy. You've got somebody who has a peanut allergy, and you may have to tell all the other kids you can't bring peanut butter sandwiches this year because of the one student who has a peanut allergy. So, you're right. I mean, they certainly, OCR has certainly taken that position before in the past.
So let's move on a little bit to talk about, there was some TEA guidance that came out on September 2nd. So Chris, can you tell us, is there anything in there that we need to be aware of?
Yeah, here it is. It's not terribly exciting. I don't think there's anything, hugely new. It focuses mostly on what to do when you have students who test positive and show symptoms for COVID. It talks about the notifications that you have to send out when that happens. It talks about, keeping them at home and following the quarantine guidelines and stuff like that. For students who are only close contacts, it makes it clear that under TEA's opinion, you may do those various things, but you don't necessarily have to. And I think that reflects, I know that last year, a lot of school districts really struggled with, they can handle the situation when a kid actually has symptoms and it is sick. But when somebody simply was exposed and through close contact, not only was that more difficult to enforce, it was very difficult to trace and very difficult to sort of keep track of. And I think that one of the things that TEA is trying to do this year is avoid requiring that because of the difficulties a lot of school districts had with it. I think they're going to tell you, you can do it if you want to, but we're not going to tell you that you have to. And then the other interesting thing, of course, and this goes back to the mask litigation about this guidance, is it specifically says under masks, please note mask provisions of GA 38 are not being enforced as a result of ongoing litigation. Further guidance will be made available after the court issues are resolved. So I think you've got an argument that, here's TEA. And what's interesting is the governor has repeatedly in all of his various orders said schools, TEA kind of has you follow TEA's rules. TEA says GA 38 is not being enforced in the schools, at least until it issues further guidance, and there hasn't been further guidance yet. So I think that's something to keep an eye on and think about if that issue comes up in your district.
Yeah, on the point about the kids being sent home for close contacts, I think interesting thing to think about is the fact that if a student actually has COVID and they come back to school, they don't have to go home for close contacts. So you could get COVID at the beginning of the year, and then I think most people are doing 90 days. You'd have a 90-day free pass where you wouldn't have to miss school. But if you're a close contact, if you happen to be a really friendly student, and you're a close contact with a number of repeated people who end up testing positive, you could end up being home over and over and over again in the semester and actually never get COVID. So just an interesting thing to think about when thinking through that guidance. All right, Holly, let's talk about vaccines. What is the lay of the land right now in Texas with vaccines?
Ever since the first vaccines were approved, Governor Abbott has, through his executive orders, made it clear that that school districts and local government entities and state agencies are not allowed to require vaccines. Again, it's similar language to with the face coverings. It cannot you cannot require them as a condition of a service or benefit. And so so that is one thing that you can't require them to do it to gain access, right? So you can't require vaccines. And as I say this word about the service, I don't think it's quite as broad as the face covering. I'll have to pull up the language and read it to you in a minute. But generally speaking, you can't require vaccines, but you can encourage the vaccines. So that is one thing to be thinking about, is we know that there are that some districts have required vaccines, just like under the same theory as requiring face coverings, that the idea being that, well, we think this executive order banning them is unlawful and therefore we're going to go ahead and require them. And that we know San Antonio ISD has been sued for exactly that position. One twist here is because of the encouragement language, some school districts have considered giving leave to employees to get vaccines. I haven't heard of any similar way of encouraging students to get a vaccine who are eligible, but with employees, some are either saying you get COVID leave if you have a vaccine, if you're vaccinated and you want to show proof of vaccination, so you're not requiring proof of vaccination. I'm remembering as I talked about this, that's the difference in the language, if you can't require proof of vaccination. So if you say we're not requiring proof of vaccination, but if you would like some extra COVID leave, show us proof of your vaccination. So that is one way that people are getting around this. Some are doing it just straight up, you get some or you don't. Others are saying that you can get additional COVID leave if you are vaccinated more than. So for example, let's say you give somebody a week of COVID leave if they are if all employees a week of COVID leave, and you get 2 weeks of COVID leave if you're vaccinated.
So what if you've got someone who might get that vaccine and might try to get that 2 weeks of leave, but they can't get a vaccine because of religious reasons or because of a physical or impairment? Do you have to provide the additional leave to those individuals?
I would strongly advise you to, yes. That when this question first started coming up, we asked around to at the EEOC, and honestly, we got different answers from different attorneys who we talked to at the EEOC. But I would certainly say the best practice would be to, yes, have an accommodation for people with a disability, allow a religious exemption. You just don't want to risk a federal discrimination lawsuit over this.
Yeah, and I mean, keeping in mind what we talked about earlier, that we can always go through the interactive process with them. And if there's something else that's available that would equally, provide them, require them to do something else, for example, to get that leave, like maybe they have to wear a mask. I don't know. I'm kidding. That would be layering upon layering of legal mayhem. So you mentioned with the religious exemption, Chris, can you tell us a little bit, how sincerely does a religious belief have to be held in order for that exemption to kick in?
Well, the law says it has to be sincerely held, and that's obviously an extremely subjective thing. We frequently get the question of whether we can ask for documentation from a religious leader or somebody like that as to something saying, this person is part of my congregation and this is something that our religion requires. We used to do that a lot. I think we always have to remember, not only do we have the First Amendment that we're dealing with, we have Texas law. And under the Texas Religious Freedom Restoration Act, which is Chapter 110 of the Civil Practice and Remedies Code, that law specifically defines religion or the free exercise of religion to not require evidence or proof that the activity is a central tenet of a recognized religion. So literally under that law, it just has to be your personally sincerely held belief for whatever reason. That is really, really hard to challenge. We frequently, so I think you can ask for something from the church or whatever, because I think that at least is a factor that you can look at in determining whether you think this person truly has a sincerely held religious belief. But I don't think it's determinative. If somebody can't produce it and says, well, it's just my own interpretation of whatever religion I happen to be or identify with, I don't think you can say you don't have a letter from your priest, it doesn't count. So under the Texas law, you literally just look at, is it sincerely held? We sometimes, when people were looking at uniforms, people were objecting to uniforms and saying, my religion, I don't wear uniforms for whatever reason. People would say, but you were in Little League last year and you wore a uniform all year long. And so you can look at things like that. I don't know with the vaccine issue if you can really find something, analogous. And the problem with that argument is the I'm trying to do better response. So when you push back and you say, but yes, you worked on Sundays, somebody might say, well, that was last year. I'm trying to do better. I'm trying to really follow the tenets of my faith now. So it's even when you can show that they haven't always done whatever they claim they're supposed to do, again, it's not necessarily 100% determinative. So I think you literally just have to look at all the facts in your possession to say, do I think this person, for whatever reason, is being motivated by a sincerely held religious belief? And at the end of the day, you're probably going to have to err on accepting what they say.
So we've only got a few more minutes, but we did get a question before we go off the topic of these incentives. Can we give employees a monetary incentive to get a vaccine? What do you all think about that?
Well, I would say that if we're talking about in terms of the executive order, the answer is exactly the same as leave, because that's exactly what leave is. That said, I would point out that if they are you're going to run into problems with the Texas Constitution prohibition on gifts, and you're going to run into problems with the fact that you're not allowed to increase the amount of somebody's compensation in the middle of their contract year without jumping through certain hoops. That doesn't mean you can't do it, but definitely talk to your attorney about what hoops you need to jump through to make sure that you're not setting yourself up for a claim that you violated the state constitution or are being irresponsible with state funds.
I think as a practical issue, Holly's right. Those are going to be the legal issues you're going to have to look at. I think you can probably articulate an argument that it's not a gift of public funds, it serves a public purpose. I think as a practical issue, the problem you're going to run into is how many employees do you have? I mean, if you give, a bonus of $500 a person or whatever, that could add up really fast. And then the other problem is by this point, a significant percentage of your employees have already gotten it. So presumably you're going to have to go back and give it to them also. I think you may have some really weird issues pop up if you say, we're going to start today and go forward. Everybody who gets one from now on, gets whatever the bonus is. I think at that point, it becomes really difficult to justify, and you're going to have, at a bare minimum, you're going to have a lot of really angry employees who didn't get the bonus. So I think at this point, those are going to be hard to implement, even if you can articulate why they're legal.
That's a good point, and it might be you might be better served having whoever is most interested in doing this spend some time researching incentives that private companies are giving and encourage and advertising those to your employees, encouraging them to go to whichever location HEB is giving $100 gift cards for getting vaccinated.
Yeah, that's a good point.
That's a great point. So I think we probably have time for one more question. We have been getting a lot of questions about what information an employer can ask or can't ask about vaccines. Holly, can you give us some quick insight on that?
So there's a misconception out there that there is a law that says you can't ask about vaccines. Now, I have not read every single bill the legislature passed last session, but I do know that the one that people are pointing to does not say that. What it says is that that state agencies and local governments can't issue a vaccine passport that other people will use to show proof of vaccination. So that's what that is about. It's not about whether or not you can ask them. That said, I've advised, generally speaking, my advice is if you're going to ask employees about vaccines for whatever record keeping purposes you are using it for information gathering, I would make it optional. Ask the question, but give people the option of whether to answer or not. And then I believe that if you do ask and they answer, that is a protected information. You can't share the answer with it at any time. So.
All right. Well, I'm not sure. We didn't get to everyone's question. Go ahead, Chris.
One last thing. I have a friend who's been texting me snarky comments as we've been going through this. And she says that in going back to the question about whether you can pay people to get vaccines, she says in her experience, a year-long Jeans Pass has more value than a lot of stipends. So that's actually a really good suggestion. There could be some non-monetary things that we have control of, not a gift of public funds. And you're right, that may incentivize people more and convince them to get out there. So thank you, Marnie.
That's great. Well, thank you all so much for joining us. We did get a question about whether we would be sharing the information. We do intend to make this recording available to those who registered. So keep an eye on your email for that information. And feel free to share it with other members of your district who weren't able to join us. Thank you so much for joining us today. We hope to see you again in a couple of weeks to talk about critical race theory. And until then, everybody take care.
Bye, everyone. Have a good day.
Bye.